So the Supreme Court just delivered what may be the most consequential ruling on presidential power in modern American history, and the implications are absolutely staggering. We're talking about a decision that fundamentally reshapes what presidents can and cannot be held accountable for after they leave office. And what makes this moment so extraordinary? The court didn't just issue a simple yes or no on whether Donald Trump has immunity from prosecution. They created an entirely new framework for presidential immunity that legal scholars are calling unprecedented, that will affect not just Trump, but every future president. And that has left both sides of the political spectrum reeling from what just happened. The Supreme Court just ruled in a 6-3 decision along ideological lines that former President Donald Trump has substantial immunity from criminal prosecution for official acts taken while in office. But here's where it gets complicated and where the real controversy lies. The court didn't say Trump has absolute immunity for everything he did as president. They created a 3-tier system that distinguishes between official acts at the core of presidential authority, other official acts, and unofficial private conduct. And the way they define these categories has prosecutors, defense attorneys, and constitutional law experts scrambling to figure out what this actually means for the 4 criminal cases Trump is currently facing. According to the majority opinion written by Chief Justice John Roberts, presidents have absolute immunity for actions within their core constitutional powers. That means decisions involving things like command of the military, foreign affairs, pardons, and appointments cannot be prosecuted criminally even after a president leaves office. Then there's a second category, official acts outside the core constitutional powers, where presidents have presumptive immunity that can only be overcome if prosecutors can show that prosecution wouldn't interfere with presidential functions. And finally, there are unofficial acts, private conduct that has nothing to do with presidential duties, where there's no immunity at all. Now, if your head is spinning from those categories, you're not alone. Legal experts are already fighting about how to apply this framework to real-world situations. Where exactly is the line between an official act and a private act? If a president talks to the attorney general about an ongoing investigation, is that an official act using executive authority, or is it private political interference? If a president calls state officials about election results, is that official outreach or private campaign activity? The court's decision sets up these questions but doesn't clearly answer them, which means lower courts are going to have to sort through the details in ways that could take months or years. Let me fill you in on how we got to this moment, because the path to this Supreme Court decision reveals everything about the legal and political battles Trump has been fighting since leaving office. After Trump was indicted in federal court for his alleged role in trying to overturn the 2020 election, his legal team immediately filed motions claiming presidential immunity. They argued that presidents cannot be criminally prosecuted for actions taken while in office because allowing such prosecutions would cripple the presidency. Every future president would face the threat of prosecution by their political opponents, leading to endless investigations and charges based on policy disagreements. The trial judge, U.S. District Judge Tanya Chutkan, rejected that argument completely. She ruled that Trump's claim of absolute immunity was not supported by the Constitution, by history, or by precedent. She wrote that the office of the presidency does not confer a lifelong get-out-of-jail-free card, and that no one in this country is above the law. That ruling seemed devastating for Trump's defense, and it set up a trial that was supposed to begin in early 2024. But Trump appealed to the D.C. Circuit Court of Appeals, and that 3-judge panel also ruled against him unanimously. They held that former presidents can be prosecuted for criminal acts and that allowing prosecution doesn't threaten the functioning of the executive branch. The panel wrote extensively about how immunity would effectively place presidents above the law and create a dangerous precedent where presidents could commit crimes with impunity. Trump then did what everyone expected. He appealed to the Supreme Court. And here's where the timeline becomes crucial. The Supreme Court could have declined to hear the case and let the lower court ruling stand. That would have allowed Trump's trial to proceed quickly. Instead, the court agreed to hear arguments, scheduled them for late April, and then took nearly 2 months to issue a decision. That delay alone was a massive victory for Trump because it meant his trial couldn't happen before the 2024 election. Now the court has issued its ruling, and while Trump didn't get everything he wanted, he got enough to fundamentally change the trajectory of his criminal cases. The immediate practical effect is that Trump's January 6th case is going back to the trial court for Judge Chutkan to determine which of the alleged acts in the indictment are official acts covered by immunity and which are private acts that can be prosecuted. That process is going to take months. There will be extensive briefing, probably evidentiary hearings, and then appeals of whatever Judge Chutkan decides. The trial that was supposed to happen this spring now can't possibly happen before the election and might not happen for a year or more. But here's where the rubber meets the road. And this is what has legal experts and political observers so concerned. The Supreme Court's decision doesn't just affect Trump, it creates a new constitutional framework for presidential immunity that will govern every future president. And the way the court defined official acts is so broad that critics are arguing it essentially gives presidents a license to commit crimes as long as those crimes involve the use of presidential powers. Let's walk through the majority opinion's reasoning because understanding what the court actually said is crucial to understanding why this is so controversial. Chief Justice Roberts, writing for the majority, started from the premise that the presidency is unique. Unlike other government officials, the president has vast discretionary authority over areas like national security, foreign policy, and law enforcement. The court reasoned that if presidents could be prosecuted for exercising that authority, they would be constantly second-guessing whether their decisions might someday be deemed criminal by a future administration with different political views. The majority opinion cited the founders' intent to create a strong unitary executive and argued that subjecting presidents to criminal prosecution for official acts would undermine the separation of powers. Roberts wrote that without immunity, presidents would be incapacitated by the threat of prosecution and unable to carry out their constitutional duties boldly and without hesitation. The court pointed to the impeachment process as the primary constitutional remedy for presidential wrongdoing, arguing that the founders intended impeachment and removal from office to be the check on presidential abuse, not criminal prosecution. Now here's where it gets really interesting and really controversial. The court held that when determining whether an act is official or private, courts cannot inquire into the president's motives. Even if a president took an action for corrupt personal reasons, if that action was within the president's official authority, it's still covered by immunity. This is huge. It means prosecutors can't argue that Trump's communications with the Justice Department about election fraud were corrupt attempts to misuse power. If communicating with DOJ is an official presidential function, then Trump has immunity even if his motive was to overturn an election he lost. The majority opinion also held that prosecutors cannot use evidence of a president's official acts to prove criminal conduct in other areas. So even if some of Trump's actions might be deemed private and therefore prosecutable, prosecutors can't point to his official actions as evidence of his intent or as context for understanding the scheme. This evidentiary ruling is potentially even more significant than the immunity ruling itself because it means prosecutors are going to have enormous difficulty building cases even for the conduct that isn't covered by immunity. Justice Sotomayor wrote a blistering dissent, joined by Justices Kagan and Gagan, that reads like a warning of impending constitutional doom. She argued that the majority just created a lawless presidency where the president can commit crimes with impunity as long as those crimes involve the use of presidential powers. She wrote that under the majority's reasoning, a president could order SEAL Team 6 to assassinate a political rival and claim immunity because commanding the military is a core presidential function. She argued that this decision makes a mockery of the principle that no one is above the law and that it will live in infamy. Sotomayor pointed out that the founders did not include any immunity provision in the Constitution, that presidents have been subject to criminal law throughout American history, and that the court just invented this broad immunity out of thin air. She noted that the court's decision will prevent presidents from being held accountable for egregious abuses of power, and that it fundamentally alters the balance of power among the three branches of government in favor of an imperial presidency. The dissent also tore apart the majority's reasoning about motives, arguing that, of course, a president's corrupt intent matters when determining whether conduct is criminal. The difference between a legitimate exercise of authority and a crime often comes down to intent. A president communicating with the attorney general about law enforcement priorities is normal. A president demanding that the attorney general fabricate evidence to overturn an election is a crime. But under the majority's framework, you can't even ask about the president's motive. So how do you distinguish legitimate action from criminal abuse? Now let's break down what this means for the specific charges Trump is facing because this is where theory meets reality. Special counsel Jack Smith charged Trump with conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction, and conspiracy against rights. The indictment alleges Trump used various means to try to overturn the 2020 election, including pressuring state officials, organizing fake electors, pressuring Vice President Pence to refuse to certify the election, and inciting the January 6th mob. Under the Supreme Court's new framework, Smith's case is in serious trouble. Large portions of the indictment involve Trump's interactions with Justice Department officials. Trump allegedly pressured DOJ to issue letters saying the election was corrupt and to investigate fraud claims that officials told him were baseless. Under the court's ruling, those interactions are almost certainly official acts covered by immunity because they involve the president's relationship with an executive branch agency he controls. The indictment also involves Trump's communications with Vice President Pence about the certification of the election. The court's opinion specifically said that the president's interactions with the vice president regarding official responsibilities are likely covered by immunity. That means a huge chunk of the case involving Trump's pressure campaign on Pence probably can't be prosecuted. What might survive? Trump's interactions with state officials might be considered private political activity rather than official presidential acts. Trump wasn't exercising any federal authority when he called the Georgia Secretary of State and asked him to find votes. That was a private citizen who happens to be president making phone calls about a state election. But even here, the court's prohibition on using evidence of official acts creates problems. Can prosecutors show Trump's calls to state officials as part of a broader scheme if they can't reference his official acts, like talking to DOJ and Pence? The fake elector scheme might also survive as private conduct. Trump wasn't using any presidential authority to organize groups of fake electors in swing states. That was campaign activity. But again, proving that scheme requires showing Trump's intent and the overall context, which includes official acts that now can't be used as evidence. The bottom line is that what started as a comprehensive criminal case charging Trump with a multifaceted conspiracy to overturn the election has now been sliced and diced into a much narrower case that can only address certain conduct while ignoring the broader context. And the process of figuring out exactly what can and can't be prosecuted is going to take months, requires the trial judge to hold mini trials on each category of conduct, and then will be subject to appeal. This case is not going to trial anytime soon. But the implications extend beyond just Trump's January 6th case. Trump faces charges in Georgia for allegedly trying to overturn that state's election. Much of that case involves similar conduct, conversations with state officials, organizing fake electors, communications with DOJ, and the White House. The Supreme Court's immunity ruling doesn't directly apply to state prosecutions, but Trump's lawyers are already arguing that states can't prosecute former presidents for any conduct related to federal official duties. That argument is going to create a massive legal fight about federalism and whether states can hold presidents accountable for conduct that federal courts can't touch. Trump also faces federal charges for allegedly retaining classified documents at Mar-a-Lago and obstructing the government's efforts to retrieve them. The immunity ruling might affect parts of that case too. If Trump's initial decisions about which documents to take with him when he left office are considered official acts, and if communications with his lawyers about responding to subpoenas involved his use of executive privilege claims, then portions of that case might be covered by immunity. The case isn't dead, but it just got more complicated. And then there's the Manhattan case where Trump was already convicted on 34 felony counts of falsifying business records related to hush money payments. That case involves entirely private conduct that happened before Trump was even president, so immunity doesn't apply. But Trump's legal team is already arguing that some of the evidence used at trial came from Trump's time in office, and that under the Supreme Court's ruling, that evidence should have been excluded. They're going to ask the judge to throw out the conviction, and if that fails, they'll appeal on immunity grounds. The political implications of this Supreme Court decision are absolutely massive, and they're going to reverberate through the 2024 election and beyond. Trump immediately declared total victory, claiming the Supreme Court just confirmed he did nothing wrong and that all the charges against him are politically motivated witch hunts that will be dismissed. That's not what the court said, but it's the message Trump is pushing to his supporters. And it's resonating. Trump's campaign is arguing that the court's decision proves he was right all along about presidential authority, that he had every right to question the 2020 election, and that prosecutors have been engaged in partisan lawfare. They're using this ruling to raise money, to energize the base, and to argue that Trump is being persecuted by the justice system for exercising his constitutional powers as president. Democrats and Trump critics are sounding the alarm that the Supreme Court just created a framework for authoritarian rule. They're arguing that if presidents can't be held accountable for official acts, no matter how corrupt, then there's no meaningful check on presidential power except impeachment. And impeachment requires a 2/3 vote in the Senate, which is essentially impossible in our polarized political environment. They're warning that this decision gives Trump or any future president a roadmap for how to commit crimes with impunity by channeling corrupt conduct through official powers. President Biden gave a rare evening address from the White House saying the Supreme Court's decision is a dangerous precedent that undermines the rule of law. He argued that the court just decided that presidents are no longer subject to the same laws as everyone else, and that this contradicts the fundamental American principle that no one is above the law. Biden warned that Trump has already shown he's willing to abuse power and that this immunity ruling removes the guardrails that prevent presidents from becoming tyrants. Legal scholars are divided along predictable lines. Conservative legal experts are praising the decision as a necessary protection for presidential authority. They argue that presidents need to be able to act decisively without fear that every decision will someday be second-guessed and prosecuted by political opponents. They point out that presidents already face enormous constraints, including impeachment, congressional oversight, media scrutiny, and electoral accountability. Adding criminal prosecution on top of that would make the presidency unworkable. Liberal legal scholars are calling this one of the worst Supreme Court decisions in history, comparable to Dred Scott or Korematsu. They argue the court just invented a constitutional immunity that doesn't exist in the text or history, and that gives presidents king-like powers. They note that the founders explicitly rejected monarchy and created a system of checks and balances precisely to prevent any one person from having unchecked authority. This decision, they argue, fundamentally breaks that system. Even some conservative legal experts who generally support strong executive power are uncarnarily, perhaps creating immunity only for clearly official acts within core constitutional powers, without the broad prohibition on examining motives or using official acts as evidence. The decision goes further than necessary to resolve Trump's case and creates problems that will haunt future cases for decades. Now let's talk about the practical timeline because that matters enormously for the 2024 election. This decision means Trump's January 6th trial cannot happen before the election. The case goes back to Judge Chutkan for immunity hearings that will take months. Trump's team will argue that virtually everything in the indictment is covered by immunity. Prosecutors will have to go through each allegation and argue why it's not official conduct or why immunity doesn't apply. Judge Chutkan will have to hold hearings, consider evidence, and issue detailed rulings. Whatever she decides will be immediately appealed, potentially back to the Supreme Court. Legal experts estimate this process will take at least 6 months and possibly over a year. By the time a trial could actually begin, the 2024 election will be over. If Trump wins, he can order his attorney general to dismiss the federal cases. If Trump loses, the cases can proceed, but it will be 2025 at the earliest. So the American people are going to vote in November without knowing whether Trump will be held criminally accountable for allegedly trying to overturn the last election. The Georgia case faces similar delays. While the Supreme Court decision doesn't automatically apply to state prosecutions, Trump's lawyers will argue it does and will fight to get state charges dismissed on immunity grounds. That fight will tie up the Georgia case for months. And even if the immunity arguments fail in state court, the case faces other problems, including the relationship between the prosecutors that has already caused delays. A Georgia trial before the election now seems impossible. The classified documents case was supposed to be the most straightforward prosecution with the clearest evidence and the least immunity defense. But Judge Eileen Cannon, the Trump-appointed judge handling that case, has already delayed it indefinitely with a series of unusual procedural rulings that legal experts say favor the defense. Now, with the immunity ruling, Trump's team has new arguments to make about why portions of that case should be dismissed. That trial isn't happening before the election either. So we're left with the Manhattan conviction on 34 felony counts for falsifying business records. Trump's sentencing is scheduled for July, but will likely be delayed while his lawyers argue that the conviction should be thrown out based on the Supreme Court's immunity ruling. Even if the conviction stands, Trump is unlikely to face jail time for those charges, and he can certainly continue campaigning and even serving as president if elected while appealing a state court conviction. This creates a surreal situation where Trump is running for president as a convicted felon in one case while the more serious federal cases alleging he tried to overturn democracy are on hold. Voters are going to have to decide whether to return Trump to power based on incomplete information about his alleged criminal conduct. They know he was convicted in New York, they know he's been indicted for January 6th and classified documents and Georgia election interference, but they won't see trials or verdicts in those cases before they vote. The broader constitutional implications of this decision extend far beyond Trump. Every future president now knows that official acts are largely immune from prosecution. That creates incentives to channel corrupt conduct through official powers. Want to extort a foreign leader? Do it in your capacity as commander-in-chief discussing military aid. Want to obstruct an investigation? Do it by directing the attorney general how to handle the case. Want to punish political enemies? Use the IRS to audit them or DOJ to investigate them. As long as you're using official presidential authority, you're protected by immunity, even if your motive is corrupt. The court's prohibition on examining motives is particularly dangerous. Intent is an element of almost every criminal statute. Prosecutors have to prove corrupt intent to convict someone of obstruction or conspiracy or fraud. But if courts can't inquire into why a president took an action, how can prosecutors ever prove corrupt intent for official acts? The majority opinion suggests that the outer limits of presidential power define what's criminal, not the president's motive. But that's a bizarre way to think about criminal law. It means identical actions could be legal or criminal depending solely on whether the president used official or private capacity, not on whether the conduct was right or wrong. Think about Richard Nixon and Watergate. Nixon was forced to resign because he used the powers of the presidency to obstruct justice, to cover up the break-in, to punish enemies, and to corrupt law enforcement. Under the Supreme Court's new immunity framework, would Nixon have had immunity for those acts? He was directing federal agencies, communicating with subordinates in the executive branch, exercising presidential powers over law enforcement. If the court's reasoning is applied consistently, much of what Nixon did might now be considered immune official acts. The majority opinion tries to address this by saying impeachment is the remedy for presidential abuses, but impeachment is a political process, not a legal one. And as we've seen with Trump's two impeachments, impeachment and removal is virtually impossible in a polarized political environment. Even when a majority of senators believe Trump incited an insurrection, they couldn't get to the two-thirds vote needed for removal because Republican senators feared political backlash. If impeachment is the only remedy for presidential crimes and impeachment is impossible as a practical matter, then presidents effectively are above the law. The dissent made this point forcefully, arguing that the majority is giving presidents a blank check to commit crimes as long as they use official powers to do so. Justice Sotomayor's hypothetical about ordering SEAL Team 6 to assassinate a political rival was designed to show how absurd the majority's logic is. The majority didn't really address that hypothetical except to suggest it was fear-mongering. But the question is legitimate. If commanding the military is a core presidential function with absolute immunity, and if courts can't examine the president's corrupt motive, how exactly would a president be prosecuted for ordering the military to commit murder for political purposes? The majority would probably say that's so extreme it would result in immediate impeachment and removal. But would it, if a president from Party A ordered the assassination of a candidate from Party B? Would senators from Party A really vote to remove their own party's president? Political polarization might prevent accountability, even in that extreme scenario. And if impeachment can't check even that level of abuse, then the immunity framework the court just created is truly dangerous. There's also the question of what this means for Vice President Kamala Harris's role in certifying the 2024 election. The Supreme Court's opinion suggests that the vice president's role in certification involves official acts that are likely protected by immunity. Trump's lawyers argued that if Pence had refused to certify the election as Trump wanted, Pence would have been protected by immunity from any criminal prosecution. The court didn't directly rule on that, but the logic of their decision supports it. So what happens if there's another contested election and the vice president refuses to certify the results? Under this immunity framework, there might not be any criminal remedy. We're potentially entering an era where the constitutional crisis that almost happened on January 6th becomes fully normalized. If vice presidents have immunity for refusing to certify elections, if presidents have immunity for pressuring vice presidents to refuse certification, if presidents have immunity for directing DOJ to claim elections were fraudulent, then what's to stop future attempts to overturn elections? The answer is supposed to be political accountability through elections and impeachment. But if roughly half the country supports overturning an election, and if impeachment is impossible, the legal guardrails just got removed. Critics of this analysis will argue it's overly alarmist, that presidents still face enormous practical and political constraints even with legal immunity, and that the court's decision simply recognizes the reality that presidents need broad authority to function. They'll point out that presidents have always had significant de facto immunity because the Justice Department has a long-standing policy against indicting sitting presidents. This decision just extends that protection to former presidents for official acts, which isn't that dramatic a change.